mga kabisdak, anak ng kagwang, oh, legit na talaga ho ito. Hindi na ho talaga maitanggi ni Luestro itong nangyayari po sa buhay niyang pinasok niya. Ito, tatanggi pa kaya ito niya, no? Dahil kay Speaker may akap. Luestro nilamon ng buhay ni Atty. Sheila Sison sa pinakaunang impeachment trial laban kay Vice President Inday Sara Duterte. Hindi nakaporma. Agad na sunog. Nang dahil kay Speaker may yakap, damay pati si Jokno, mga ugag, mga ubog pa lang mga ito, barado din kay Atty. Sheila Sison. O ano kayo, mga bubunistang, tanganistang, loyalista ni Bake. Tibag lahat ng mga hinayupak. Unang araw pa lang nga, awards, oh. Iyak na, Jinky. Ito, nagmistulang ugag at tanga naman itong si Gatchalian, anak ng kagwang, sa impeachment trial. As in, nagiging puppet lamang ho siya dito. Wala siyang alam, lumulutang sa hangin lang, anak ng kamote. Nakita nyo yung podium? Dalawa po ang nakaupo dyan. Ang isa si Judas Iscariot. Yung isa si Gatchalian na tuta ni Bangag. Dalawang Senate President. Diyos ko, nakakahiya ka, Gatchalian. Dapat nag-resign ka na lang. Wala ka palang alam sa batas, putang inumin naman talaga. Ito, magandang gabi po sa ating lahat. Palike po muna, pa-share at pa-subscribe. At pakipindot po ang inyong mga notification bell upang lagi po kayong updated sa ating mga video. Aba, siyempre, nais ko po munang pasalamatan yung mga nag-super thanks. Marami na po kasi naipon. Maraming salamat, Ma'am Vivian Figueroa, Ma'am Marnie Reed, Prima Bilya Colita, Ma'am Beth Goodsan, Larina Tikia, Lilith Taguno, Sara Ambali, Lulia, Larina, Tikia ulit, Elizabeth Linsangan, yan, maraming salamat po sa inyo, mabuhay po kayo sa mga nagpa-super thanks. Ito na. Bago po natin umpisahan kung paano po nilamon ng buhay ni Atty. Sheila Sison itong dahil kay Speaker may akap, nagkaroon po muna ng kaunting commotion sa pagitan ng minority, Senate minority at Senate majority. Dahil pinagbabutuhan po ito kung sino po yung magiging papabor na maging presiding judge, itong si Chis Escudero, na ang nagmotion nga ho nito ay si Pinky Panpilulakson. Alam mo, Gatchalian, nagmistulang tanga ka at ubog ka at nagmistula kang limdak na Senate President. Anak ng kagwang, pagkakataon mo na sana na patunayang ikaw ay deserve sa pagiging Senate President, pero wala. Useless ka, wala kang kapangyarihan. Ito, pakinggan po muna natin ang pagtatalo po nito. Narito po.
Mr. President, when you object, you're allowed to explain your objection and state your objection.
Senator Lacson is recognized. Thank you. Your Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials, as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this impeachment court.
Objection, Mr. President, and may I allow to...
We proceed
Objection, Mr. President, I'm allowed to object and I'm allowed to explain my objection.
You're allowed to object, but we will proceed with the division
Mr.
of the
President,
House.
point of order.
Those who are,
point of order, Mr. President.
in favor of the
Mr. President, you're allowed to explain para ma-convince mo nga yung iba.
Raise your hand. We will vote by raising of hands. So, those who are in favor of the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand.
Siyempre, mga kakampi ni Tuta Soto. Ayan na. Nagtaas na po yung team ng Senate of Malacanang. 12 po ang mga hinayupak. Tanginumin, pag may mag-object, saka ka muna magbutuhan. Ang bubo talaga ni Gatchalian. May nag-object eh. pakinggan mo muna yung objection.
Explain my vote, Mr. President.
Hold on. Allow the chair to make a ruling.
Mm.
Those who are against to the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand.
Tingnan mo, 8 po yan sila. Yan ang totoong mga mambabatas na sumusunod sa batas. Grabe yung bobo talaga ni Gatchalian. Bago ka magbotohan, pakinggan mo muna yung nag-o-object. Bakit sila nag-o-object? Para malaman kung ano yung dahilan, bakit may objection. Tingnan mo, pagkatapos magbotohan, saka pa pinagsalita si Cayetano, useless na yun.
The count is 12 in favor, 8 against. The majority,
Putang ina,
those
nagkalaglag
who
na
are
yung...
in favor, has it.
Mr. President,
The court resolves to elect Senator Chis Escudero as presiding officer of the impeachment court. The duly elected presiding officer shall, under the same oath taken on May 18, 2026, immediately assume and exercise all powers, functions, duties, and prerogatives pertaining to or vested in a person presiding over the impeachment trial under the rules of procedure on impeachment trials.
Tingnan mo.
Amended and shall give full effect to the powers inherent to the courts under Rule 135, Section 5 of the Rules of the Court.
Ang bobo talaga tong si Gatchalian. Alam mo, Gatchalian, ikaw yung pinakabobong Senate President. Dapat pinagsalita mo muna yung isang Senate judge sa kanyang objection para mapakinggan ng mga ibang senador bakit meron siyang objection. Hindi yung nagbutuhan ka na tapos pagkatapos ng butuhan, pinagsalita mo siya, hinayupak tong animal na Senate President, walang alam. Okay, nagiging presiding judge na po itong si anak ng kamote, si Escudero. Alam mo, ito ay pinagbabawal sa saligang batas, labag po ito sa Constitution, bend the law po ito. Dahil dapat po ang maging Senate presiding judge ay presiding officer ay si Senate President, si Gatchalian. Kung hindi mo kayang maging Senate presiding judge, dapat nag-resign ka at si Escudero na lang ginawa mong Senate President. Ayan po yung numero. Solid yung 8 na minority. Ayan magkapatid na Villar, Robin Padilla, Amy Marcos, Loren Ligarda, Bungo, Pia Cayetano, at Senator Alan Peter Cayetano. Si Senador Marcolita ay hindi na po nakasama dahil sumuko na po sa Sandigan Bayan dahil sa akusasyong plunder laban po sa kanya. Kung nandun lang si Marcolita din, 2 sila ni Cayetano, 3 silang mga abogado, no? Si Pia at saka si Alan yung na magtatanggol dito pagbardagulan. Ayan po. Pero sinayang mo, Win Gatchalian, yung pagkakataong ito. No? Kung ikaw ay totoo kang Senate President, meron kang kakayanan, dapat hindi ka nag-elect ng presiding officer at si Escudero na nga. Pero ito, nagmistula siyang tanga. Nagiging puppet lang siya dito ni Escudero, anak ng kagwang. O ito, umpisahan na po natin mga kababayan ko, itong paano lamunin ni Attorney Sheila Season itong si Jingle Huestro. Kasi si Jingle Huestro may motion na gustong paatinin si Vice President Inday Sara ngayong araw dyan sa hearing, anak ng kagwang. Pero hindi po iumubra itong si dahil kay Speaker may AX, talagang nilamon po ng buhay ni Attorney Sheila Season itong bumubula na bibig po, nakakaya. Literal, again, bumubula talaga bibig ni Huestro. Kita, Diyos ko. Kadiri kang hinayupa ka. Pakinggan po muna natin to mga babayan ko narito.
And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per article basis after the conclusion of the trial of this impeachment case, Your Honor.
Chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lead
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, The motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have
It's answered
mentioned, Your
about the
Honor.
Yes or no, Your Honor.
Rule
Is the
7.
lead prosecutor
Rule 9
is the lead
Let this
prosecutor
not be a debate between the
requesting
councils.
for the respondent accused to
Council
be arraigned, Your
correspondent,
Honor.
kindly make your comments and avoid asking questions from the council or the
Yes or no lang
We will
kasi.
recognize the council correspondent for comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7, Rule 9, and Rule 21. However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if you take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Finally, under Rule 21, Your Honor, may I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with the rules on rules of procedure of this court, then we can enter her plea on her behalf.
Oh, ano na, Luistro? Talo dyan si Luistro sa kanyang motion. Panalo po si Atty. Sheila Season. Tuloy lang natin.
Salus populi es suprema lex. The wealth
O, Supremalix. Ano yun? Duplex? Okay, so anong round? Panalo si Atty. Sheila Season. Hindi po pinagbigyan ng impeachment court itong si Jinky Luistro. Ito naman yung yung opening remarks, no? Hindi ko na ipapakita yung buong opening remarks ni Luistro kasi bula-bula bibig niya. Ang pakinggan natin yung sagot ni Atty. Sheila Season kung paano siya nilamon ng buhay dito. Pakinggan natin, no?
welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted.
Tingnan mo,
Opening remarks for the respondent.
tingnan mo, itong si Gatchalian, nagmukha siyang tanga. Pansinin si Gatchalian. Wala siyang alam. May isang boses wala. Pag ganun-ganun ka lang ng papel, papakli-pakli lang. Ito nagiging Senate President ka pang hinayupak ka. Tuloy, oh.
Counsel for respondent has 15 minutes and we will give you the same latitude we gave
Ayan na, pakinggan natin si Atty. Sheila.
Additional 3 minutes.
Ganda ng birada niya dito.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust, and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 25, 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do.
Ayan, tuloy lang natin. Tindin. Sharp na sharp. Oh.
But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration, and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini trial, and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds.
Tuloy lang, opening remarks ni Atty. Sheila Sison.
That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued the Special Allotment Order number SARO-BMP-C-22-001-2004, signed by former Secretary Amena Pangandaman, to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for the consideration of that decision, that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing In the notice of disallowance, or COA decision states any findings of supposed misuse of confidential funds as confirmed by Attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but a speck of particle or molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o alegasyon na napapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit ang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan.
Narinig nyo yan, tambaloslos at bungit, tuloy lang.
One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.
Grabe, ang galing.
Open
Attorney
statement of the
sila.
counsel for respondent. Duly noted.
Iyak si Luestro, Jinky, yes or no, hindi masagot eh. Powerful yung opening remarks ni Attorney sila Season. Panoorin natin susunod na mangyayari.
And entered into the records. The court will now proceed to dispose of some of the incidents that were brought up during the pre-trial conference, as well as other pending matters and motions. First, on the sequence of the presentation of the articles of impeachment. The pre-trial order stated that the prosecution has a free hand to determine the sequence of the presentation of the articles of impeachment. However, respondent will be similarly accorded the same right insofar as the presentation of their evidence and witnesses in chief is concerned. Maybe now learn from the public, from the panel of prosecutors rather, what will be the sequence of presentation of the articles of impeachment that they intend to pursue. Attorney Jokno is recognized. You may proceed, sir.
Thank you, Your Honor.
Ito na. Panoorin po ninyo kung paano binara ni Attorney Sheila Season si Jokno. Laki ng ngipin, para mukhang kabayo. Okay, pakinggan natin, panoorin natin.
The first article we will be presenting will be Article 4 on grave threats. Second will be confidential funds, Article 1. Third, bribery, that is Article 3. And the fourth is unexplained wealth, Your Honors. That's Article 4.
No, two.
I'm sorry, Article 2. I stand correct.
Ang inumin. Magbabasa lang, hindi pa marunong magbasa. Ang 2 nagiging 4. Ang 4 nagiging 2. Talo na kayo dito. Okay.
Corrected.
So the sequence of presentation shall be Article 4, Article 1, Article 3, and then Article 2.
Yes, that is correct, Your Honor.
So I presume that beginning tomorrow, once we issue the subpoena for your first set of witnesses, you shall begin with Article 4.
Yes, Your Honor.
Tingnan nyo naman si Gatchalian. Pansinin nyo naman. Tangin na Senate President yarn o puppet yarn. Wala, tango-tango lang siya dyan. Kung sinasabi ni Escudero, wala siyang inik. Walang alam ang animal. Putang inumin mo, nakakahiya kang Win Gatchalian. Oh.
Again, Chair rules that the respondents have the same and equal privilege of presenting its case as it so desires when it's time to present its evidence in chief shall come. What is the pleasure of the counsel for respondent?
Ito na.
Thank you, Your Honor. May I ask if the prosecution is ready to present its first witness today because the defense is ready today, Your Honor?
We will get to that later. Next
Your
item
Honor,
on the
please.
agenda.
If Your Honor, please.
Yes,
I
Representative
just
Jokno.
noticed that Your Honor had already directed the counsel for the defense not to propound questions to the prosecution.
Hello.
It's already the second time that she's doing that. She appears to be assuming or arrogating the powers of the court. Because as I understand the rules, it's only the court that can propound questions to the counsels.
Your Honor, may I comment?
The lady may comment.
I
Counsel
take
for respondent
exception
may
to
comment.
that. Yes, Your Honor. I take exception to that manifestation of the good counsel. In fact, the record would show, and if we can run the transcript back, my question was addressed to the presiding officer, Your Honor.
Let us move forward. Gentleman and lady.
Nasaktan si Jokno. Tangin na, ang linaw-linaw yung address na Attorney Sheila Season sa presiding officer, Your Honor Tangin na, bumagting yung tainga ni Jokno. Na sinasabi ni Attorney Sheila Season, kung ready na ba kayo yung unang witness ninyo na ipresenta ngayong araw dahil ready na ang depensa. Sagupain kayo, putang ina. Arugante daw. Sila Season. Iyak ang mga animal. Tuloy, galing.
Next
Sila.
item for us to dispense with, the witness disclosure rule. The prosecution proposed a 3-day witness disclosure rule. The respondents proposed a 5-day witness disclosure rule. But they understand the prosecution is amenable to the 5-day witness disclosure rule. Would that be
Yes,
correct,
Your Honor.
Representative
We are
Jokno?
amenable to the 5-day disclosure rule.
Chair therefore rules that insofar as disclosure to both to either party of a witness to be presented, not mentioned in the pre-trial order and or briefs of the parties shall be for 5 days. This is subject also to the chair's reminder that at the end of every week, that would be a Wednesday while we are on recess, we will ask the party presenting their case in chief to enumerate the witnesses they intend to present for the following week, with the corresponding motion for the request of issuance of subpoena to be submitted the day before or on Tuesday, so that we can act on it before the last day of the week, so that the subpoena can be properly issued in due course and in due time.
So,
Ordered.
So ito na yun, magsupina na ng mga witnesses. Akala ba natin na handa na yung mga witnesses na mga hinayupak na to? Ready ng depensa. Tuloy natin ng konti.
On the examination of a witness by more than one counsel as propounded or proposed by the prosecution, the rules of the Senate are clear. Article 15 of the Rules on Impeachment states, witnesses shall be examined by one person on behalf of the party producing them and then cross-examined by one person on the other side. Court therefore rules that as a rule only one person shall present a witness. However, in the exigency of the delivery and the administration of justice, and under certain exceptions, the court may allow more than one counsel to examine and or propound questions to a witness. To cite an example, just for the sake of the record, if, for example, the panel of prosecutor disagrees with how the counsel for prosecutor is handling the case, the panel of prosecutors or one of them can take over, and that is but proper and should be allowed and will therefore be considered as an exemption to that rule. And other similar exigencies will be allowed in order to afford the orderly administration of justice and of these proceedings. So ordered. Insofar as the BIR box is concerned.
Oh, sa BIR box.
What is the pleasure of? Insofar as the BIR box is concerned, this box was turned over to the Senate as part of the documents, including the articles of impeachment. However, the court is not yet in custodia lehis of this box, given that there is no lawful order issued by the court for this box to be turned over to the Senate. More so that it is not yet offered in evidence, not even as of yet marked. The chair therefore orders that the BIR box, closed, sealed, and as it is received, be sent back to the BIR or the Bureau of Internal Revenue without prejudice to any action that the court may take if a motion will be filed by either party for the issuance of a subpoena, and we shall await action, if any, by the BIR Commissioner should that time come. So ordered. Now, insofar as the subpoena requested by the prosecution for the two NBI agents, may I request the clerk of court.
Putsang ina, ito na. So binalik na po no sa BIR yung BIR box. So wala na 'yon. Jinke, talo na kayo, Jinke. Anak ng kamote oh. At magsasumpina na po ng mga witnesses ng mga prosecution. Sino ang mga witness, mga hinayupak na yan? Yung mga sa yung sa bangko di Nenday Sara, lahat na nga pinagsumpina nila lahat. O ito mga kababayan ko, ang gusto kong pansinin ninyo, yung dalawang tao dyan sa pudyum, sa watawat ng Pilipinas, yung isa nasa asul, yung isa nasa pula. Ito yun. Pwede pala, dalawa ang nasa pudyum sa impeachment trial, parihong senador, yung isa Senate President Kono, yung isa presiding judge Kono, yung presiding judge ay...
Nandito na ang Pinas Updates. Huwag kalimutan mag-like, share, comment, and subscribe sa ating YouTube channel. Maraming salamat.